would be Pradeep Pal. It should be included. This instant matter appear under heading to be mentioned for correction in the judgment date. Item number 2. My lord, I am appealing for the petitioner. My lord, this is a revisional application against affirmation of a conviction under section 325. Well, 3 persons faced trial. 3 persons were convicted under section 325 by 34 for a period of 2 years and to pay a fine of rupees 1000. Now, subsequently, they preferred an appeal. In the appeal, 2 persons were acquitted. However, the conviction of the present petitioner was affirmed. Against that, I have come before this honorable court. Now, in appeal, 2 persons were further acquitted. Out of 3, 2 acquitted, 1 remaining. Now, my lord, for that, my lord. Now, my lord, primarily, I have come up before this honorable court on 2 grounds. One is on merits, the other one is on a technical point. Well, on merits is the present petitioner was convicted. Subsequently, his conviction was affirmed because PW3, the injured, he said that the present, you are here, Najrul Kabir, and Abu Sufyan and Fajrul were acquitted. Kabir was acquitted by the appellate court. My lord. Okay. Now PW3 is the injured person. During his evidence, he said that the present petitioner there was a family dispute. They were cousins. There was a dispute relating to property. Civil suits are pending in between them. Now, he said that he gave a fist on his nose, for which he received bleeding injury. Now, this was stated by PW3 during evidence. He is the injured person as well as the injured person victim. And the my lord. Now, in the FIR, there is no averment that this petitioner gave the fatal blow on the nose. It was a fist and blows by all the persons. In the 161 also, there was no allegation that this petitioner gave the blow on his nose. Only for the first time in court, he stated that this petitioner gave the blow on his nose. On the basis of that statement, he was convicted. Now, my lord, is there any medical document was medical document, my lord? It was medical document is my lord. আমাকে এলসিআরটা আছে, আমি দিন আমি বার করে দিচ্ছি। দিন আমাকে বার করে দিন। Apart from PW3, is there any other eyewitnesses? Well, PW1 and PW2. PW1 and PW2. They have corroborated. They are the father and the mother. They have corroborated. They also did not state before the police or in the FIR about the petitioner. It was an omnibus allegation. exhibit file কোথায়?
IO was examined.
My lord. But IO
Is PW?
PW7 is the IO. The doctor said that such injury can be caused by fall on ground also. Now, my lord, the IO said Sarmat Nawaz did not mention in his statement that the accused stated.
You have annexed the deposition of
No,
the
my lord, no.
witnesses? No.
But it is in the LCR, my lord. My lord, I am
Come
just.
to the judgment. Come to the
My
judgment.
lord, that has not been dealt with by the learned magistrate or the
Okay.
learned judge.
Okay.
The evidence.
You are showing PW3.
My lord, PW7, my lord, I am reading it. Page 32 of the LCR. Sarmat Nawaz did not mention in his statement that the accused persons assaulted him. I can't read the handwriting. And Nujrul Kobir gave a blow on his nose, and he by his teeth. So the IO confirmed that such statement was not made before him. এই দুটো পাতা একটু
ডিপোজিশন ছিল ডাউন
আমার কাছে নেই।
আছে
না, আমি এখান থেকে দেখি এই যে এই পাতাটা এইটা আর 32
even in medical
no names were given.
no name medical document no names has been specified by whom he was assaulted.
My lord.
And in FIR?
FIR also omnibus, all three. লাইভ ল আর এতে তো প্যারাগ্রাফ মিলছে না।
No, FIR specific name is mentioned.
Three, my lord, names.
Specific name is mentioned.
My lord, all three.
All three,
Now,
but
two have been acquitted.
Maybe acquitted. They cannot support the case of
Now, my lord,
prosecution.
My lord,
That's why they have been
my
acquitted.
lord, he has been differentiated. In the FIR, it was said 3 persons assaulted with fist and blows.
না চেষ্টা করলে গণেশ নজরুল ফরির পিতা সোয়েন্সো সোয়েন্সো চল চর কিল ঘুষির লাথি দিয়ে মার.
So, my lord, there are three.
So 3 persons.
3 persons. My lord.
If prosecution fail to prove against 2 persons, they will be acquitted.
No.
But if prosecution proved a case, positive case against 1 person,
My lord,
what would be the result?
My lord, for that, my lord, I will be relying upon a judgment.
Because the person himself stated before the
My lord, specific allegation against this particular person.
Yes.
Corroborated with the medical evidence. That is good enough.
My lord, I would be relying upon a
medical document. There is no specific
note.
name.
Even in the 161, he did not state.
FIR, there was a name, by name, that 3 persons assaulted.
My lord, that would be 323 also. The 325 is for the blow which the present petitioner gave.
Fracture nose.
Now, my lord, that is.
Fracture nose,
My lord, no X-ray was even exhibited.
No?
X-ray plate or X-ray report.
What doctor says?
Doctor says, my lord, she relies upon the document, her medical document.
That is sufficient.
No, my lord, but for that, she is supposed to rely upon a medical document.
lower trial court report.
My lord, may I rely upon a judgment of the Honorable
Please
Court?
come to the evidence of PW3 first.
My lord.
He has corroborated the FIR. He specified that out of 3, one has assaulted by blow in his nose. That's why he suffered injuries.
My lord, I would.
So that is a specific allegation.
My lord, the
against-
specific allegation would have been accepted, my lord, if he would have made that statement before the investigating officer or during the course of his medical examination. In the medical examination, he did not make any statement.
That
Now,
may not be.
now in his 161 also, he did not make that statement. And my lord, apart from that, my lord, it
Please
was.
wait, please wait. Go back. PW3.
কি বলছো? সে তো বুঝে যাচ্ছে।
Very specific his evidence.
My lord, his evidence is
I'm saying that
specific,
I
but
came to
he
the
has not
spot.
stated.
I came to the spot and raised objection. All the 3 accused person assaulted me with fist, blow,
So
kick,
these corroborates the FIR.
and the accused person, and snatched. And during that time, Nazrul Kabir gave a severe blow on my nose,
My lord,
and I have sustained injury.
my lord,
An
this
FIR is not
no, my lord, the
not
first
supposed to.
Be the insult.
my lord,
And
my lord, that is FIR is not the encyclopedia. So my lord, the first portion remains as it is. It corroborates the FIR. Now that portion has been disbelieved, for which they have been acquitted.
regarding other witnesses, PW1 and 2.
PW1 is the father. Now my
Other
lord,
has specified anything
my
about
lord, kindly come to the cross-examination of the investigating officer.
1 minute, 1 minute. Let me see other eyewitness what they have said. Nawaz was present.
No, the independent witnesses are PW4 and PW5.
4 and 5.
4 and 5.
4 and 5 are my lord post occurrence witness.
No, my lord, they didn't saw. They only saw the.
They are the post occurrence witness. How they will say?
But my lord,
See,
1 and 2 are my lord the person.
whether any.
They
any
found bleeding
statement
injury
made
on
by
the
1 and 2.
Have the copy of the depositions, but from the judgment, what it reveals that 1 and 2 was there while that assault was there.
my lord, I will serve a copy upon of the deposition.
This is specific. Fazlul Kabir and Nazrul Kabir assaulted his son on his nose with blow and sustained severe bleeding injuries on his nose.
My lord, this statement has been made for the first time in court.
Each and every details cannot be given in FIR.
No, my lord, not in FIR, but before the.
All the 3 persons were present at
My
the
lord,
spot.
My lord, it
All
is
the 3 persons assaulted him.
all the 3 persons, 2 were acquitted.
And a
My lord, I would not have
specific
any
blow
case
was
if
given by-
those 2 persons were also convicted. But those 2 persons has been acquitted. There is no
Maybe
cross
5
appeal.
person
Now, my
out
lord,
of
if
5 or 6 person, 5 may be acquitted, 1 may be convicted. If prosecution prove the case in positive against 1, that is sufficient.
but my lord,
Is there any contradictions regarding this assault?
My lord, there is
During cross-examination.
in the cross examination, the doctor has said this injury can also be caused due to fall. Now, my lord,
Maybe that is a suggestion. That is a suggestion.
now, my lord, there is no X-ray mention.
Is there any contradictions between any of the witnesses?
My lord, there are contradictions, my lord. I will
Please show me the contradiction.
But my lord, before that, my lord, what I am submitting, the Honorable Supreme Court says if any statement.
I will come later, the judgment part.
Now, my lord,
Well, I come to the facts.
then my lord, I have to come to the cross examination also. My lord, kindly come to PW1.
Yes, PW1.
Out of 3 accused persons, 2 accused persons are present today, another accused is absent. The incident took place on 13/5/2006 at about 11 a.m. to 11:30 on in front of the house at such as at PS Bagnan, District Howrah. On that day, I erected a wall room on the.
During cross-examination, it is clarified that I did not narrated the incident in detail to the doctor. I did not state to the doctor who assaulted my son and how. You
Well,
have clarified everything
No,
in your own cross-examination.
he has said that he has not stated.
Yes,
So whatever he has stated in court is for the first time.
maybe.
My lord, if it is taken, if it is made for the first time in court, it cannot be considered. My lord, the Honorable Apex Court has said if the prosecution witnesses have failed to mention in their statement under 161 CRPC about the involvement of an accused, their subsequent statement before the court during trial regarding involvement of that particular accused cannot be relied upon. So, my lord, because they have not stated in their 161. My lord, the print is little hazy, my lord. Paragraph 31.
Involvement.
My lord.
What does it mean?
Well,
Involvement. If there is no specific involvement in the FIR that Mr. X and Y so and so was not present there,
Well, I'll
then
bring.
then the questions comes first time in court. But in this case, all the 3 persons were present in the spot. They have assaulted continuously by fist and blow to someone. Now, who will specify?
No, my lord,
Suffered injury.
now, my lord, may I submit?
He is the best witness.
My lord, may I submit?
Not only that, the other witnesses also supported. The medical document also supported there was an injury in nose, fracture.
My lord, fracture without.
What requires now?
Now, my lord, he has been singled out due to a statement that he gave the blow on nose. In case the 3 accused persons would have been before you, my lord, then my lord would have been able to convict all 3. Now, if when those 2 persons have been acquitted, whether this petitioner falls on the same footing like that of the same. But I will bring the other judgments also.
Prosecution witnesses have not stated particular activities or particular role played by other 2 accused persons. That's why the trial court convicted. Subsequently, appellate court found no, there is no specific role attributed against them. So they have been acquitted. But in your case, specific abutment made by the.
My lord, I will bring those judges where the on the basis of there should be a specific
I
abutment.
have said that if there was no any mention about the name in FIR or involvement of the accused persons or the convict in the FIR, then the question would be different.
My lord, the involvement and the act. The involvement is the act. Now the
It
act,
is proof that there was a dispute, family dispute,
My lord.
many cases pending.
so my lord,
between-
if there is a family dispute,
Number
then
two,
it can
there
cut
was
both
an
ways.
assault. Someone suffered injuries.
My lord, if there is a family dispute, it can cut both ways.
Yes, yes, both ways.
Now, my lord, when they say that these three persons were jointly assaulted him in their 161. Now, in the court, they say that this person who assaulted me, my lord, I'll give a better copy of that judgment, my lord.
Any
And I will
other
also bring
judgment
the
do you
other
have?
judgments.
Do you have any other judgment?
Well, I will bring the other judgments. There are many other judgments relied in this,
So now you are not ready today.
my lord. I will bring the other judgment because I was under the impression that since involvement is the act,
20% may involve in an incident. But if particular role has not been proved by the prosecution, what court will do? Everybody will be convicted
my
because there is a assault.
now the
Assault must
my
be a
role comes
particular.
in court. My role prior to evidence, my role is along with two others. Now in court, my role comes, my specific role.
Yes, that's why I am
Now,
asking.
my lord, if that
your specific role is you have assaulted in the nose, where
my
he
lord, I will
sustained
my lord, I will
fracture
bring that
injury.
judgment, my lord. Whether because if that specific averment is not made before during investigation, whether it can be made in cannot be considered at the time of trial because they
Yes,
are developing the case.
When you will bring?
Well, give me 2 weeks time, my lord.
No,
1 week.
I have already heard this matter twice occasion. 1
2
week
weeks.
sufficient.
Well, kindly give me 2 weeks. Except
Next
16th,
Friday.
16th instead of 9th, 16th.
Uh,
Well, item number 3, I am for the petitioner. But today I have a very bad voice, Malad. May I come back tomorrow?
not today.
Not today.
Okay, not today.
Short passport. My lord, I'm on instruction of his clerk, lordship. I'm praying for a short passover in this matter, lordship.
Okay, you bring the CD.
CD
is available. Okay, Passover.
Passover, lordship.
Not today. Okay, not today.
Lordship, lordship. Not today.
Your Lordship, on item number 5, appear for the petitioner may be permitted to appear virtually, Your Lordship. Your Lordship, on item number 5, there are talks of compromise going on between the petitioner and the opposite party number 2, Your Lordship. I pray for 3 weeks of time, Your Lordship.
What is your instruction?
Lordship, we have just received it yesterday only that they are ready for it. We have just received instructions from the other side, the advocate for the petitioner yesterday that they are okay with the.
What is your instruction from your own client?
I have to
Whether
seek
he is ready to-
instructions. I have to seek instructions because I have just received the
What
confirmation
is the
yesterday.
matter about?
Your Lordship, it is a civil matter, Your Lordship. The petitioner was awarded as environment impact assessment work by the opposite party number 2, Your Lordship. It's a commercial matter, your lordship, civil commercial matter, your lordship. As such, your lordship.
Any money is involved?
Yes, your lordship. The petitioner was awarded.
Since 2020, yes.
3 lakhs.
He took the money for some work, he did not complete that work. Hence the revenue.
Your,
Instruction,
Lordship, I shall take instruction.
not this week.
great.
Lordship, some more.
Instruction whether there is any scope for settlement or not, then only I will adjourn.
Lordship.
Otherwise, you have to
Grateful.
be delayed.
Very well, your lordship. Great.
I am keeping only not this week. Next week I will take up this matter. In the meantime, you take instruction.
I'll seek
From your
instruction.
client.
Grateful, Lordship.
Grateful.
But one indulgence to your lordships, my lord. With respect to item number 3, my lord, I persuaded my
Not
I did not today,
next today.
as your lordship.
Next day I will take up.
Lordship, item number 6 and 7, I am appearing for the petitioner and led by Mr. Shomi Ganguly. He was supposed to do the matter today, but due to some problem, he couldn't appear, come in the court.
Whether
There-
your client is ready to do this matter, because many occasion you have sought adjournment. Last occasion also none was there. If your client is not ready to do the matter, I will release this matter.
Lordship, as per the instruction from my senior, he would do the matter in the next week. So kindly fix it on the next week on Sunday.
Release this matter. Six and seven same.
What 6 and 7?
6 and 7 same.
Like, I am for the petitioner. This is against my rejection of my Naraji petition. The state was directed to produce the case diary.
On the prayer of
Nine and 10, Lordship. I'm for the petitioner.
who is appearing for the petitioner?
Mr. Shomi Ganguly.
Sumir.
Shomik, Mr.
Not today.
Not today.
Not today.
9 and 10. আমার বলেছে না হ্যাঁ সন্ধ্যা রানী 10 number it is on সন্ধ্যা রানী সন্ধ্যা রানী হ্যাঁ not today করতে না
11.
Your Lordship praying for not today.
Why?
Your Lordship, the learned senior counsel has went
You
for-
do the matter.
Your Lordship, I'm not. Yes, Your Lordship, he went for the last rituals there.
Having heard the submit, having heard the
Well, Lordship, I'm appearing for the petitioner.
you do the matter.
I don't have to read.
Every matter you are seeking adjournment, you are only for seeking adjournment here. Next time you will bring your brief and you do the matter.
Gotcha.
If your senior is so busy, he should at least assign the matter to the junior. They can proceed the matter. You will be ready next day. Not to.
No, this is my application. I am for the petitioner.
You take down the submission made by the petitioner, and next day I will allow you to submit.
No, this is 125 proceeding. Wife is the petitioner, my lord, before your lordship. No, this is initially interim maintenance was awarded in favor of the petitioner. Kindly come to page 29.
Your wife,
I am the wife.
how much maintenance was
The
there?
15,000 was awarded as interim maintenance. But the
15,000.
husband initially, husband my lord, is a primary teacher.
Interim
Interim
maintenance
15,000. He is the primary teacher.
Okay.
Well, challenging that order, he preferred a revision before the learned sessions court. His ground of challenge was on twofold. Number one, while considering the interim maintenance application, learned magistrate did not consider the affidavit of assets of both sides. Number two, he was not present at the time of passing the order by the learned magistrate.
Ex parte.
Ex parte. On that score, my lord, the learned sessions judge was pleased to set aside the order passed by the learned magistrate.
Set aside, not reduced.
Remanded. Matter was remanded to before the learned magistrate, directing him to consider the matter afresh in the light of the affidavit of assets to be filed by both sides. Thereafter, both sides will file their respective affidavit of assets. After considering the affidavit of assets, suddenly the learned magistrate reduced the amount from 15 to 5,000.
What was the ground?
No ground, nothing. No reason has been
Is there
assigned
any
by
liability of husband
nothing,
towards other family members?
nothing. No observation, no finding. Absolutely unjustified order that I have
Do
challenged.
you have annexed?
Yes, that is the
affidavit?
certified copy, the present one.
No. Do you have annexed the affidavit filed by the husband?
Yes, yes.
Where is that? Mitali Vaidya, you have annexed
54.
50?
54 of is the affidavit of assets filed by the husband.
54.
54. Column number 3, he has mentioned that he is a primary school teacher.
52. Come to the 52.
So, Amar, 52 is the continuation of the affidavit of assets of the wife petitioner.
Wife? No. Saroj Kumar Vaidya.
54 is the relevant page. That is the affidavit of assets of the husband.
Starting from 52. Come to the page number 52. Date of marriage 1997. Date of separation 2015. General monthly expenses 10 to 12,000 per month. Matrimonial suit is pending.
Oh, page is not matching.
Met
My brief it is
execution, husband
54.
awarded in favor of the wife.
Pagination.
Fast track court to Barasat. Basirhat awarded maintenance.
That is in respect of matrimonial suit.
6,000 per month.
Yes. Subsequently, suit has been dismissed due to non-appearance of the husband plaintiff. Matrimonial suit praying for divorce
by the husband. You made an application
Yes.
for maintenance.
Alimony pendentolite was awarded 6,000 per month. Subsequently, suit was dismissed for default.
So your application has been not considered by the
No, 6,000 was awarded.
awarded.
Subsequently,
Finally,
suit has been dismissed. Suit, there is no existence of
he
suit.
is paying 6,000 as per the order of the civil court.
Civil court. He was paying initially.
We have not paid any maintenance. In that suit,
I am the wife.
you have not made any application for maintenance in matrimonial suit.
The matrimonial suit, I made an application praying for alimony pendent delight. In that suit, my lord, 6,000.
Even if dismissal of the matrimonial suit, interim maintenance can be continued.
That 6,000 awarded, 6,000 was awarded.
Hmm.
Now he is not paying any further. 5,000 in the one.
You have
Yes,
not
yes, I made that
any
application.
for execution.
Thereafter, I did not.
You did not. So that amount should be considered by the.
That should be considered.
By
Now
the
I am pursuing in
judicial
125
magistrate.
proceeding. Now I am pursuing in 125 proceeding. 125, 15,000 was awarded
That is
initially.
the income shown by him. Monthly income as per income.
He has mentioned in my brief, it is page 57.
Was 28,000. 2,80,851.
Yes, 851.
He has not made any specific income. He has mentioned if you divide into 12, how much it will come?
2,80,851. 2,80,000 divided by 12. 2,80,851 divided by 23,404. 404.
As per his income tax filed during 2022 to 2023, 3,99,890 per year. And 2018 and 19, his income reduced to 2,80,000.
In 2020, 2022, 2023, it was 3,99,890.
How income tax can be reduced? Salaried person. Income always increase. What type of affidavit of assets filed by the husband? 3,99,000 reduced to 2,80,000. 1 lakh reduce. How it could be?
My lord, on that, my lord, I need some instructions.
To take instruction.
I have made an RTI. I have made an application under the provision of RTI Act. Now his salary is 49,910.
Around 50,000. Yeah.
This is the present status.
And at the time of filing, how much is income?
Well, according to his affidavit of assets, around 25 or 30.
25,000. So anything else from your side? Anything?
No.
More submission?
No. Now kindly see the order impugned. 21st of March 2024. 35 copy, last page.
Yes. No discussion at all.
No discussion.
And this is the final order.
This is the interim.
Interim.
Challenging interim, my lord, revision was.
What is the matter about the final hearing of the?
Now I have challenged that order before this honorable court.
What is the stage of that?
There has been no progress. As of now, evidence has not started.
Not started. Okay. Affidavit of service.
My lord, kindly grant.
File on behalf of. And on that day, otherwise I will dispose of this matter. Yes.
14, my lord, I'm appearing on behalf of the petitioner. In this matter, my lord, charge sheet has been filed during the pendency of the proceeding. I'm praying for 2 weeks' time to file a supplementary affidavit, my lord.
Charge sheet has been filed, you go before the trial court. You avail your remedy there. Thereafter, if required, you come again.
My lord, in that case, please kindly keep it not today because that is my instruction, my lord.
Charge sheet has been filed. You go before the trial court, pray your prayer before the trial court for
Sir,
discharge if
not
you have
today, my lord.
case.
The advocate on record will appear, my lord. Kindly keep it not today.
Huh? So, okay, I'm keeping not today.
My lord, my lord.
You take instruction. I will dispose of you. Go before the trial court. The trial court will not consider your prayer. You may come.
Last time they also take time.
Then this is the last chance. Huh? On the prayer of
Fifteen Lordship, I'm praying for not today.
Oh. Next time you bring the file. I will not allow.
Lordship.
Not today.
Last time I'm praying for not
Why?
today.
Why?
Actually, in this one, last time Mr. Subir Banerjee appears for the petitioner lordship. Yes, he came lordship, but he's left the court lordship.
Who is appearing for the opposite party number 2?
Last occasion,
A direction was given to serve the notice to the opposite party. Whether
Lordship, whatever lordship, I forget lordship.
I am
Yes,
keeping not today.
Not to the lordship.
Okay. Please bring affidavit of service on the next date.
Seventeen, I'm praying for not today.
Same prayer, not today.
Play 18, kindly make it not to the one.
My lord, I'm applying for the OP number 2.
Not today.
Nineteen Lordship, I am praying for not today. I am led by Mr. Sabir Ahmed in this matter. He is on his legs in an appeal before courtroom number 8. Appeal is going on, Lordship.
You start.
Lordship, I am praying for only a day's accommodation, Lordship, on the next day.
Last occasion also you have asked for adjournment. Before that you also asked for adjournment. Your client is not ready to proceed with the matter.
He is ready, Lordship. So, the matter arising out of section 498A. Charge sheet has been filed under section 498A. Against two other co-accused persons, the proceeding has been quashed by the coordinate bench of this honorable court. And the husband is now before your lordship for praying for quashing of the proceeding, lordship. Mr. Ahmed has some arguments to make, lordship. I am praying for only a day's accommodation. On the next day, we will satisfy your lordship.
Bring that judgment also.
That is annexed with the writ petition. That is annexed with the application, lordship, passed by the Honorable Justice Sampad Ottopal. The mother-in-law and the sister-in-law.
Okay, not today.
I am grateful.
Your Lordship, item number 20, I'm led by Mr. Milan Mukhali. I'm praying for not today in this matter, Your Lordship.
Not today.
Yes, Your Lordship.
Top of the list. This was kept.
No, Your Lordship. I would just inform Your Lordship.
Who is the other side? CBI. Not today.
Much obliged, Your Lordship.
Twenty-one, my lord, I am for the petitioner. Our submission was completed. In the last occasion, I was directed to serve a notice upon the opposite party number 2, which I have done. My lord, here is my affidavit of service. Complaint.
This is matter relating to
This is a complaint case, my lord. Financial, not sure.
you have completed your argument last occasion.
Yes, my lord.
You have come against the order of trial court regarding
Yes, my
issuance
lord.
of process.
Yes, my lord.
You have served upon the learned counsel.
Yes, my lord, I have served on the council.
Affidavit of service filed on the What is the stage of the proceeding? Do you know about the proceeding? What is the step? Huh?
In the lower court, for that I have to take instructions, my lord.
You file report.
207 papers were submitted. 200 papers were supplied to the accused persons. Thereafter, they have come up for the before your lordship for the questioning of the entire proceedings, my lord. Lord, your lordship has heard this matter at length, my lord. But they have not completed their argument.
That's why I'm asking for the present status of the proceeding. Thereafter, if no one turn up on behalf of the petitioner, I will dispose of this matter.
Deep level, my lord.
No, 23 kindly make it not to the one.
2007 matter.
7 matter, my lord, it was heard by coordinate bench. State was directed to produce the case diary. I am led by Mr. Ghosh. He has some difficulties to table. Kindly fix it.
Coordinate bench heard this matter.
Yes, yes. It was heard by other
So
bench.
why it is appearing here?
No, thereafter, due to change of determination, it came before your lordship.
Determination has been changed.
Yes.
Now the coordinate bench has no
The
determination.
lordship will hear out the matter.
Not kept part heard.
No, no, no.
What do you want now?
Kindly make it not today, next week.
Okay, not today. Listen. Uday Kumar. What is the determination? Determination list. Release this matter.
No, I'm applicable for the petitioner.
Honorable state that your lordship had directed the president to produce in spite of all efforts I because the final court has come. Now, my lord, either your lordship hears the application on merit. Otherwise, we'll have to again. Case of 1999.
Why unable to produce?
By the wall efforts, the statute was filed in 2001. The discharge hearing took place in 2018. So the original case diary was with the learned public prosecutor, was allotted the brief at that point of time. Now the GR section is unable to find out the copy. Even asked.
I am asking the Assistant Commissioner of Police to appear before this court in virtual mode.
Or either that, or I had instructed the investigator.
No, I will ask him to appear before this court on virtual mode.
Before doing that, what I received your
Last occasion, you asked for adjournment on the ground that you will produce the case diary.
What I had instructed the investigating officer to make a prayer before the judicial magistrate for the copies. If your lordship gives us the last opportunity, then thereafter.
2018, you are unable to produce the original. Even if you are unable to produce original, you should produce the xerox copy or photocopy of the case diary.
That is what it should be. That is how it should be.
Simply one letter indicating that the case diary is lying before the trial court.
I had
The excuse for not bringing the case diary.
to make a prayer before the learned judicial magistrate also. If he is unable to lay his hands on any of the Xerox copies, I had asked him to make a prayer before the judicial magistrate for obtainment of a copy from the learned public prosecutor, whoever.
If the case diary is lying before the trial court, that can be obtained because the matter is pending before the High Court. And High Court repeatedly asking to bring the original case diary. What steps taken by the police authority?
That instruction is also perhaps not correct because it cannot be with the learned trial court. The case diary is allotted to the public prosecutor who is in charge of that particular matter. Now this case has come before your lordship after the discharge prayer was rejected. So our learned public prosecutor has already been appointed. There's no doubt because he must have been part of that hearing. So that case diary must have been lined with that learned public prosecutor who might have been depaneled, might have been retired.
Whatever may be the reason, but case diary must be returned to the concerned authority.
That is why
That case diary must be lying with the police authority.
So I had instructed him to make a prayer before the learned judicial magistrate as well. Since the record must have been there. And he gives us one opportunity, thereafter Malad Lordship will pass with the
And PP should inform the authorities what is the process to collect the CD. If one CD is not available or not press out,
It should be preparing duplicates.
there should be other CD in other offices. You know very well.
Copies.
At least there must be a 3 copies of CD. So
That is what I had instructed the opposite people.
you also instruct and give him direction to collect CD from other department or other offices. Yes. So in this way, matter cannot be dragged due to non. Yes, now called old matter. Declare করে the old matter. বলে দাও.
Old matter. Old matter item number 49.
He report from the handwriting expert is a weighted journal. Kindly give me I call for the presentation whether the report has come.
What handwriting expert? Report.
Check your
They were convicted under section 323. Read with section 34.
49, the আমার 50. But here, conviction was given under section 323. Three 341, 323, and
What you have submitted?
from the victims total malak 6 prosecution witnesses were examined.
No. Today you have submitted one report. What is this? This is in this case or another case?
But in this case, I have not submitted any report.
Earlier one. Okay. Out of 3, I think Sambhu Das expired. And Pintu Mukherjee was also expired and his case has been awaited. Now only Prasanto Pokhre. Prasanto Pokhre alias Sibu is here. In absence of the accused, how can I hear this matter?
Yes, but only one happened.
Can you inform him?
I'll inform him. Today is the first day of the year. Let him come.
वो लिख दिए मतलब 50 I am for the petition.
Anyone is appearing from the side of state?
Mr. Sujan Chatterjee for state.
Susan Chatterjee.
The fourth
Maybe earlier matter, he was the petitioner, so probably he has not come today. Malak makes it not today, Malak, next day.
Not today. Inform Mr. Susan Chatterjee.
Cholo ho gaya.
And who is appearing for opposite party number 2?
On several occasions, notice was sent to the learned advocate, but he is not appearing.
Not appearing. Non same order. Dismiss for default. Same order.
Lordship, I am led by Mr. Dipanjan Letter. He could not able to make his submission due to bad voice. I am praying for not to do.
Not today. Dismissed for default, same. Interim order vacated. No, this is not complaint case, state case. Dismissed. Yes, you can go. নাম নিয়ে নিন। This is regarding transfer of the proceeding from one court to another. Can you file the status report?
Yes, sir, we will take the necessary
Instructions.
There are to take the case number and
Dismissed. Complaint case. Interim order vacated. Same order. Same.
Yes, correct. 60 to 63.
Well, 62 and 63 are same matter model. Under
I appear for the state in this matter, my lord.
state provision is central. State normal party state. Number over this issue, your lordship has caused several matter. Your lordship may remember that provident fund matter, bunch of cases your lordship has caused. This is out of those matter, 2 cases remain pending. And after passing of your lordship's order, other matters were also caused, citing the old lordship judgment by coordinate bench. These are those matter which has been disposed of by quashing the proceeding, several proceedings. Your lordship may remember for a particular month, a bunch of period, the 91
You
cases.
have already
All
deposited, all payment was made.
No, it was not with respect to payment. Submit of return, your lordship may remember.
This is
Because when
also
there was
regarding-
question of payment, then 468 would have not been applicable. But in this case, it was merely submission of return. And central government has made a notification that these continuation of these proceedings are futile exercise of litigations. So all matters were quashed. So my lord, I have given 2 bunch of orders. There are orders also. At least 32 matters were quashed. They filed 91 prosecution respect of 1.5 year. Failure.
Yes, do you have anything to say?
If it is a provident fund, madam, my lord, the state has
Nothing to say. You can serve the copy.
But I will
I have already disposed of many cases. Coordinate bench also dispose of many cases.
My lord.
Kept CAB করে দাও,
হ্যাঁ দাদা।
Hearing concluded, CAB রেখে দাও।
দুটো ম্যাটার আছে।
Both 62 and 63.
কোনটা নেবে দেখো, প্রথমটা তুমি তাহলে নিয়ে নাও 3047
CAB.
মাইল demobilized.
আমি প্রথমটাতে আছি। আমি নাম দিয়ে দিচ্ছি।
And in second?
In the other matter, my lord, Thorjati Datta is appearing.
I will serve him copy. I will inform. I will serve a copy and I will inform that your lordship passed the order. I am giving his name. ঠিক আছে?
He is present in court today?
দেখেছো তুমি? ঠিক আছে।
Yes, come.
Yes, come. Give your name. Give.
I'm giving the names, man.
দিয়ে দিচ্ছি।
Appearance টা দিয়ে দিন। Appearance.
But I'm giving the name.
Deeply obliged.
Dismiss for default.
Lordship, subject to leave, Lordship, item number 44. I am for appearing.
Wait after 3 minutes. Remains. Same order. Dismiss for default.
Sixty-four.
64. You give your name. Same order. Dismiss for default. 66. Same order. Dismiss for default. Same. Please appear someone from the state in this case. Is there anybody in
Item number that, item 68.
item 68?
Sujata Das is appearing for the state.
One order has been passed by the trial court. The dead body could not be identified, and subsequently it was sent for DNA test and waiting for report.
Lordship, I kindly make it not today. I will inform Sujata that.
Sujata
She
is appearing. Okay, not today.
She is already appearing, my lord.
So you inform.
My lord.
Yes. What is the mentioning?
Lordship, regarding item number 44, Lordship, I am appearing for the petition. And Lordship, it was
44 not called today.
maybe Lordship, but it was wrongly listed under the heading more contested application, and in spite of that, Lordship, it is under heading the extension of interim order.
It should be under heading
Extension of interim order because
44.
the can already been filed, Lordship.
44.
Yes. Kindly let-
44. Extension of
March of Great.
My lord, 86, my lord. Your lordship was 84, 84, my lord. Lordship has given me the last chance, my lord. I have complied the order today and also the last 2 days, my lord. Let my compliance be recorded, my lord, today.
It will be called on next
Last
day.
chance.
Next day I will call on.
Because it was recorded last chance, my lord. Though it is a fact in record, my lord, that every day I was appearing and your lordship's order, I have complied. Direction was to fresh service.
When
and
I
have
call
complied
this
the order.
matter, you submit. I have not called today.
Item number 178, read hearing, if it can be taken up Wednesday at 2 p.m. my lord, because the
170.
178, read hearing. If it can be taken up Wednesday 2 p.m., I shall ask my advocate on record to serve a notice on Monday to the petitioner.
Take up on Wednesday. It will be taken up. Hearing matter.
My lord,
It will be taken up.
go down in the list.
Why it will be good?
Sir, kindly take it up at a fixed time, because there are some urgency involved in the case.
Yes, your matter is second or third.
Yes.
169 to 177 and 178.
My lord, if time can
Please.
if a time can be fixed, my lord.
No, this is their second matter.
Actually, petitioners are not coming. That is, I am for the respondent.
I will dismiss.
I'm grateful.